Managing global privacy compliance feels overwhelming? Expanding into new markets is exciting, but navigating dozens of privacy laws is not. The rules change, expectations rise, and compliance becomes a constant moving target. How confident are you in your global privacy readiness today? Privacy Rules is the world's only global alliance integrating legal, tech, and crisis communication experts under one coordinated umbrella, delivering unified privacy solutions across more than 55 jurisdictions. We simplify global compliance, mitigate cyber risks, and protect your company's reputation with scalable, 24/7 expert support across borders. From multi-jurisdictional data breaches to international data transfers, privacy policies, market expansion, and M&A due diligence, we provide tailored, cost-effective privacy solutions for your global operations. With simplified contracts, centralized case management, transparent processes, and dedicated global support. Our alliance gives you confidence and clarity wherever you operate. Simplify global compliance. Protect your organization with the world's leading integrated privacy alliance. Contact Privacy Rules today.
Welcome back, everyone, for this Privacy Rules Data Protection Day event. I hope you are enjoying the day, and I also hope, and that's why I was saying welcome back, you enjoyed our session of this morning. And now we are going to follow up with a bunch of 4 more sessions that will be quite different from the ones of the morning, where we have been speaking generally about frameworks related to cybersecurity and data protection. We delve into class action, incident response, as well as the digital omnibus. But now we're moving to more sector or topic-specific sessions. And the first one of today is going to be on children data protection, or minors data protection, as they can be called differently from one area of the world to the other. Before moving to that session, for the ones that are joining Privacy Rules for the first time, I just would like to share with you that who we are. Privacy Rules is a unique global alliance that bridge gap between law, technology, and crisis communication. We have experts in over 50 jurisdictions worldwide, and we provide a one-stop shop for organizations that want to integrate legal counsel, cybersecurity forensics, and strategic crisis communication. To follow on the discussion of today, the first session, as mentioned, is going to be dealing on minors data with experts from very different areas of the world, all of them under the moderation of our guest moderator, I would call her, for this opportunity from MLEX, which is Sarah Brandstatter. I hope I've been pronouncing her name in the correct way. Hi, Sarah. It's a pleasure.
Hello. Yes, very well. Thanks so much.
I think I leave the floor to you to introduce everyone on the topic of this session and to the other panelists. So I'll set behind and looking forward to listening and learning a lot from you all. Thanks a lot for being here, to you and also to our audience.
Thanks so much, Alessandro. Dear ladies and gentlemen, and everyone in the audience, welcome to today's panel, where we'll speak about the global race to protect the digital youth. My name is Sarah Brandstatter, and I'm a tech journalist at the news outlet MLEX in Brussels, where I cover data protection and platform regulation, of which the whole issue or topic of protection of minors online is a really big part and very high on the political agenda. Let me start with saying that I think most decision makers and companies, if not all, would agree on the statement that the protection of children and young users online is really important and has become a priority for many of them. However, I think when it comes to the question of how this should be achieved, the debate gets started. Over the past few years, we've seen regulators aimed at driving systemic change, combating illegal and harmful content online, and protecting young users better. Notably, there's the UK's Online Safety Act and the EU's Digital Services Act, both at which impose new duties on platforms to improve user safety. But those are just some parts of the whole puzzle. And also across the globe, in different jurisdictions, lots more is happening. So I'm really happy that we have three experts with me here today to discuss this timely question. Let me introduce them. First, we have Luisa Sato, who's a partner at Tosini Fredi in Sao Paulo, where she advises Brazilian international clients on data protection, digital law, and IP. She regularly works on complex compliance and governance issues at the intersection of privacy, technology, and regulation. Thanks for being here. We have Stephen Matthias, who's a partner at Kocher & Co., where he heads the firm's Bangalore office and co-chairs the technology law practice. He brings a comparative perspective shaped by experience in India, the UK, and the EU, and is advising on technology regulation and data protection. Hi, Stephen. And third, we have Carla Guimont, who's a senior legal counsel and data protection officer for France at the video game publisher and developer Ubisoft, where she's been working as data protection officer for the past 7 years. In her work, she's focused a lot on minor protection and the digital gaming environments. Hi, Carla. Thanks so much for being with us. And since we have here experts from 3 different parts of the world, let's get started with a bit of a global overview. And let me start with, the debate in Brazil is really high on the agenda at the moment on this topic. So maybe to this international audience that we have here today, can you give us a brief outline on the Brazilian framework and also what you see as its key policy choice compared to what's happening here in Europe?
Sure, Sarah. It is a big pleasure for me to be here with you on this very special day. So in September last year, Brazil enacted a new framework for the protection of children and adolescents in digital environments. It is known as the Digital ECA, which is an acronym in Portuguese for Statute of the Child and Adolescent. It enters into force only March this year, a few days from now, and it complements both the LGPD, which is the Brazilian General Data Protection Law, and updates existing child protection rules for the digital context. This law was the result of regulatory evolution combined with strong social pressure, so the legislative process was significantly accelerated by intense public and media attention. This was triggered by viral content published by a well known influencer here in Brazil, exposing the risks of child exploitation and harmful content on digital platforms. What is particularly interesting is that the debate reached an unusual level of political consensus here in Brazil. So voices from across the political spectrum was aligned, far right, far left, and as a result, online child safety became a top public priority, pretty much like what we have seen in Europe. So the new framework will apply when there is a sufficiently high probability of use or appeal to children and adolescents, ease of access and use by that population, and a significant degree risk to privacy, safety, or biopsychosocial development. With this legislation, Brazil joins a growing group of jurisdictions that have adopted a dedicated legal framework for the processing of children's data. But unlike some international proposals, Brazil does not ban, for instance, social media for minors. There are specific obligations regarding the matter, such as accounts of users up to 16 years old must be linked to a parent's or legal guardian's account. Also, similar to the European approach, Brazil shifts the burden of age verification onto the platforms themselves rather than relying solely on parental responsibility. But there's also an important structural difference from the EU. So Brazil is a big continental size country, but it is only one country. So this avoids the challenges Europe faces in harmonizing interpretations across multiple member states. Finally, Brazil did not create a completely separate children's data protection regime. This did not happen. Instead, it chose to strengthen the principle of the best interests of the child within its existing data protection, consumer protection, and minors protection frameworks.
Can you hear me now? Great. Thank you so much, Luisa. That's really interesting also to hear about this consensus, because at the moment, the debate in Europe and also what's coming from different member states, for example, isn't really like that. So there are lots of different approaches to it. So now let me jump to Stephen. How would you characterize India's approach to this whole issue of protecting minors online and also processing of children's data? And also, how or where does it diverge from the EU model?
Sure. Thank you, Sarah. The first thing we need to know is that India does not have a comprehensive data privacy law that's in force at the moment. We did have the DPDPA, which was enacted in 2023, and the government a few months ago notified when the law will come into force, and it will actually come into force in May of 2027. The government has given an 18-month period for businesses to comply. Now, that 18-month period, the government is considering reducing that to 12 months, but hasn't done that yet. So the date for compliance is still May of 2027. Under the new law, a child is defined as a person who's not completed 18 years of age. So 18 years is a fairly high bar compared to the rest of the world. The controller has to obtain verifiable consent of the parent of a child before processing personal data of a child. Significantly, there seem to be some gap here in the sense there does not seem to be an obligation to verify whether a user is a child or not. Of course, that's a very difficult thing to do when there's no self-declaration that by the user that the user is a child. There's a general prohibition on undertaking any processing that's likely to cause a detrimental harm to the children. But leaving aside the consent requirement, there is a requirement that a controller cannot undertake tracking or behavioral monitoring of children or targeted advertising directed at children. This is probably the most controversial part of this law. Now, the government can exempt certain processing from this, from the requirement of consent, and also this prohibition on tracking, behavioral monitoring, targeted advertising, and so on. So there are some categories that the government has notified under its rules. So the first category are really, uh, you know, healthcare, education, childcare, and so on. And processing here really relates to, health services, educational activity, and safety. So, for example, a child is going, through transportation, then you want to track where the child is, so that would be fine because it's safety issue. Then there's another category which covers really three types. So one is exercise of power under the law and providing government subsidies. So that's mostly relating to the government. Then having a user account and communicating by email. So that is actually permitted, um, including real-time location for safety. And then the third one is verifying age itself and preventing access to harmful content. So you can track a use of a child accessing content in order to make sure that the child is not accessing content that's harmful, that's like age inappropriate and so on. Now, in terms of verifiable consent, there are really two requirements. One is using appropriate technical and organizational measures to obtain consent, and the second one is due diligence to check that person identifying as a parent is an adult. So the I guess there are two parts to it. One is the consent part, and one is the prohibition on tracking and monitoring. As regards the consent goes, um, India has some unique kind of tools. So we have, what's called DigiLocker. The government's proposing to use tokenization, and then we have Aadhaar verification, where essentially you have a biometric-based identification that pretty much everybody in the country has. So once a child declares that X is the parent, then you can use the Aadhaar method. Is an SMS will come to the parent. The parent has to put in a one-time password, and that gets verified by the Aadhaar authentication system, and that's a form of consent. So that may not be as hard as it seems because of the fact that India has these new age kind of tools. But I think the bigger one is on advertising and behavioral monitoring, particularly when it comes to content. So you're using YouTube or Netflix, and you want to recommend to a child that perhaps you can try this program, or watch this content, then that might not actually be permitted under this new law.
Thank you so much, Stephen, for this very comprehensive overview. And now let me go to Carla before we'll talk a bit more about this whole age verification question. So, Carla, we just heard from Brazil and India. Also, I talked a bit about the European framework before. So, I'm really wondering how Ubisoft, as a global company, is handling this kind of patchy situation of child safety laws across the globe.
Yes, thank you, Sarah, and thanks for having me. So to answer your question, indeed, when you are a global company like Ubisoft, the legal framework is very fragmented. So concretely, our approach is based on three main principles. First, we have a common global foundation built on the highest standard of protection. In practice, this often means putting the best interest of the child as a primary consideration. Second, we adapt our practices with local specificities. So some countries go further, so we make the necessary adjustments. The goal is to meet all local requirements without creating completely different experiences for players around the world. So if I take a concrete example, in the US, COPA requires a verifiable parental consent, and this is something we have implemented as a local requirement. And third, we focus on anticipation. Child protection has become a major priority. So we don't just think about compliance today, we also think about the future. What will authorities expect next? How can we design systems that can evolve over time without having to rebuild everything every year? So in practice, it means strong internal governance and close collaboration between legal and operational teams.
Yeah, that's very interesting. So you plan ahead for sure. I would really like to talk a bit more about this whole question of age verification and data processing now with the three of you. Because it's really one pressure point globally when it comes to child protection and kind of this question where it collides with privacy, cybersecurity, and also AI. So maybe we continue with Carla. Can you share a bit more in detail what's Ubisoft's approach to this topic and protecting young players online and also finding this right balance between collecting and protecting their data?
Yes, sure. So at Ubisoft, our approach to protecting young players online is really about finding this right balance, enabling a great and safe gaming experience while collecting only the data that is strictly necessary. So you mentioned age assurance. We are seeing that authorities are asking companies to go beyond simply asking players to declare their age, including in the gaming industry. So we are exploring solutions. We know that odd identifier like ID documents or payment methods are reliable, but involve collecting sensitive data. So it can raise privacy and security issues. Other methods like automated age verification can reduce data collection and still provide sufficient accuracy. So we are investigating to find a solution that is effective, minimize data collection, and remain respectful of the player experience. And on top of age assurance, we have already implemented in our systems age-appropriate accounts with protective settings by default and parental controls. So how this works in practice, we have two main types of accounts. The first one, child accounts, for players between 7 and the local age of consent. These accounts are highly protected and linked to a parent or legal guardian account from the start. And the second, teen account, for players from the local age of consent up to 18 years old. And on this account, we have two layers of protection, protective settings and parental controls. So first, we apply protective settings by default. For example, profile visibility is limited, social interactions are restricted, in-game purchases are blocked, no content personalization or marketing communications are sent by default. And then we provide parents with concrete parental controls. So they can adjust spending limits, chat restriction, and friends lists. They also receive monthly reports and real-time notifications for certain events, such as purchases or friend requests. So by protecting minors, we really build trust with our users and their parents, which is so important to support our success. And talking about trust, it also comes from a fundamental pillar of privacy, which is transparency. So in addition to this minors account, we developed a simplified version of our privacy policy designed to be understood by everyone. So we use clear, plain language. We focus on a visual that is appealing for minors. We tested the document with real users, including minors. So normally we test our games with play testers, and this time we get their feedback on our legal documents, and it was
Mhm.
very interesting. So the goal was really to focus on what is really important for them, make sure they understand what we do with their data, help them know their rights and exercise them. So in short, our approach combined age-appropriate accounts, protective settings, parental controls, and we focus on transparency.
Mhm. Thanks so much, Carla. Turning now to Luisa, maybe if you have any reactions to what Carla said and what they are doing, that would be great to hear. And then also more specifically for Brazil, I know you wanted to share some kind of best practices from the Data Protection Authority with us.
Sure. So I loved listening to Carla speak because it seems like Ubisoft really checked all the boxes for our new law. It seems like Ubisoft would be a role model for the law. So this is incredible work, Carla. You should be really proud of your company. Under our new law, companies are expected to operationalize compliance, focusing on key actions, many of them already mentioned by Carla, but mapping the processing activities involving minors. I think this would be a number one topic because after that, you can choose what you're going to do with that. Reviewing legal basis under our data protection law with special attention to parental consent mechanisms, updating privacy notices and user interfaces to ensure that information is clear, it is age appropriate, it is easily accessible to both children and their parents, implementing or reviewing age verification mechanisms, and always applying data minimization and proportionality, implementing, Carlos said that also, parental supervision and control tools whenever that's applicable. In many cases, it is not. Conducting impact assessments. I think Carla also covered that. And also, very important, training the teams. This is specific in our law. We also have sector-specific obligations for instance, for social media platforms, for electronic games like Ubisoft, and online art advertising. And yes, you're right, Sarah. So I would like to mention that our DPA did a tremendous job. They published a big study on age verification, and so it collected experiences from all over the world. And I think although that's not really mandatory for companies in Brazil, we can expect a lot of that to be part of the new regulation. It is important to mention, I don't know if I did this before, that the same authority that it is responsible for enforcing the data protection law, the ANPD, is also in charge of enforcing the digital ECA. So throughout this year, the authority will issue specific regulation on all and on everything that we said today. And on this comprehensive study on age verification in digital environments, we can expect this to base a regulation on the matter. It also serves already as a valuable reference for companies preparing their compliance strategies.
Thank you so much, Luisa. And now, Stephen, after you've heard all of this from Luisa, but also from Carla, generally speaking, what's your advice now to a company that currently processes some kind of children's data? What should they do now? I mean, I'm guessing what Carla said, like planning ahead and looking ahead what could happen, would be a very good first step.
Thanks, Sarah. Firstly, I'd like to say I think Ubisoft is doing a great job on this, and I really like to compliment on them on that. And also, what the Brazilian authority is doing with a worldwide kind of survey, I think that's also really great. I'd actually like to read that survey. I'm sure it'll be very useful for me as well. I think, because the law has not yet come into force, everyone's fairly at the starting stage in India. And I think the unique tools we have here can be useful for Indian companies. So one other that I thought I would mention is the law actually provides for consent managers. Now, it's not like other countries don't allow consent managers. It's just that the law in India specifically provides for it and also has the obligation for a consent manager to actually get, registered. So, for those who find the whole consent mechanism, whether for adults or for children, difficult, then using a consent manager would definitely be the way forward. The different tools available like DigiLocker and Aadhaar and so on could be fairly easy ways in which Indian companies can obtain verifiable consent for children. Uh, um, and the the technology is all available. I think Aadhaar by and large has not been used by the private sector very much. It's used extensively in government services. So, I sit on the boards of many companies of my clients, particularly foreign companies that are just set up in India, and I'm constantly getting what we call OTP, other one-time passwords that are Aadhaar based because I'm the director on the board for verification, and those are government services. So I think we can very much move that to the private sector as well.
Thank you so much, Stephen. I'm just checking if we have some questions from the audience, and I do see one, so I'll read it out to all three of you. How do you reconcile conflicting best interests of the child standards across borders? So who wants to take that? Would be interesting to hear from the three of you. Luisa, maybe you have any thoughts on it?
Sure. So, what I would do, I would adopt what I already do with data protection issues in general. So, whenever we have an issue that covers different countries, we usually tell our client to adopt possibly uh, uh, the most conservative standard applicable in all of those jurisdictions. But of course, this will the company will have to use a risk-based assessment. So that would also be important to do, possibly an assessment on this matter. But in all cases, adopting the highest standard would be the most conservative approach, in my opinion.
Is this something that you're doing, Carla? I know we talked a bit about in the beginning, but like adopting the most conservative approach everywhere. I think you also talked about having different set of rules depending on the location, right?
Yes, sure. And I think that it's not necessarily in conflict with business, because I think this is a lot what we can think. Putting the best interest of the child can be a limit to the business, but that's what I was saying. Trust is so important, and in the gaming sector, even more. Players needs to be confident with what we are doing with their data, and it helps also engaging them. So yes, putting the best interest of the child, building a minors account and all the protective measures helps also the business and the trust.
Stephen,
Um,
any thoughts?
Yeah, I think here there's a trade-off between two approaches. One being the take the most conservative approach versus we'll adapt country-wise. The first one means there's probably an easier fix, but it does mean that you're being more conservative and narrower in countries where you don't need to be because there may be some few outlier countries that are very strict. On the other hand, if you do it the other way, then you spend a lot more effort and time on technology in having different standards for different countries. But then you're able to comply in all countries, and you're able to use have greater flexibility and freedom in countries where the law is more liberal.
And I see we have one more question here, specifically for Carla. So, from your experience, How do governance and international coordination influence a company's ability to respond to enforcement risk in the area of child protection online?
Yes, so from my experience, governance and internal coordination are really key when managing a big project like minor protection online. This is not something a single team can handle alone. Multiple teams are involved: legal, security, online product, marketing, customer support. And if all the teams don't collaborate from the start, regulatory requirements are often addressed too late, reactively instead of proactively. And we know it's much better to handle this from the beginning. And in practice, this coordination goes through regular meetings, shared roadmaps, and priorities that we define together. And this approach not only makes the project successful, it also makes the work motivating and interesting, in my opinion. I learned a lot from seeing how other teams approach the same challenges. And I think another important point is training teams. The DPO team help other teams understand privacy and minor protection issues. And by training them, compliance becomes a natural part of how we work. It helps teams spot risk earlier, ask the right question, and design stronger solutions. So strong governance and coordination improve also our ability to respond to regulators. Decisions are documented and teams can clearly explain not just what was done, but why and how. So in short, governance, coordination, and training are essential. They let us anticipate risks and show concretely that child protection is built into our decisions.
Thank you so much, Carla. I think this is a perfect note to end this panel, a call for cooperation on a topic I think that will stay with us for much longer, and there will be more questions to answer. Thanks so much to the audience, to everyone listening, and to the three speakers here sharing your expertise. And now back to Alessandro.
Thank you very much, Sarah, and thank you very much also, Carla, Luisa, and Stephen. That was a really interesting, insightful, and practical session. Often, too short time, so we also apologize for the questions that were coming that we couldn't answer, but we will definitely keep them for further materials in the future. So thanks a lot for sharing them with us. So we move now to another topic. We had this session which we called One Internet, Many Childhoods. I would also say many jurisdictional approach that sometimes are different. So there is a need, of course, to coordinate and align. The next session is going to delve into another sector particularly sensitive, which is the one of health data. And this title is indeed Health Data for Innovation and Upcoming Revolution. Is that a revolution or not? That's something we definitely want to touch upon together with our expert. So I'm pleased to introduce you to the moderator of the session, which is Anushka Sachdev from the Belgian law firm and member of the Privacy Rules Alliance, Timelex, which of course has a strong expertise in the sector. This session will be a bit different, meaning that we will also use some slides. So I leave the floor to Anushka to introduce the panel and the approach. Looking forward to learning a lot also in this new session. Thanks a lot for being here with us.
Thank you, Alessandro. I hope everyone can hear me well. And thank you for the lovely introduction. First, I will quickly, like Alessandro mentioned the topic, use of health data for innovation. Is it really a revolution? I would quickly introduce the other panelists as well. So first, we have Sara Capillo. She's the Corporate Governance Coordinator at Grupo Fleury in Brazil. So she's a results-oriented leader with a deep understanding of Brazilian healthcare regulations. She's also skilled in navigating complex legal landscapes, mitigating risks, and driving operational excellence. She's also passionate about leveraging legal expertise to foster innovation and ensuring ethical business practices. She's experienced in leading cross-functional teams to achieve strategic objectives while building strong relationships with stakeholders. Her core competencies include corporate governance, data privacy and protection, integrity and risk management, contract negotiation, and regulatory compliance. Another speaker is from across the globe. She is Mariela de la Guardia Oteza. Apologies for the wrong pronunciation, if at all. She's a partner at Icazza Gonzalez Ruiz and Aleman in Panama. She's a lawyer specializing in corporate law, intellectual property, data protection, among others. She has assisted multiple foreign and local companies in their assessment on data protection in Panama, from regulated companies to entrepreneurs. She represents ICASA in privacy rules and INTA's data protection committee. She's a part of the board of directors of Verdes & Co., a company dedicated to the development of hydroponic crops, and is secretary and director of ICASA Trust Corporation and IGRA Foundation. She's a member of AmCham Panama, the Panamanian Association of Intellectual Property, the INTA, and the Directors Association of Panama, the National Bar Association, CICYP. So we are very glad to have these speakers here. So first, I will quickly go through the European health data space, which is the main legislation we have in Europe at the moment. And then we will get to Sara and Mariela to enlighten us on the developments in their countries. So starting with the timeline of the EHDS, in March 2025, EHDS entered into force for the primary use of data. We will get into the intricacies of what primary use is and secondary use is later. In March 2027, we are supposed to have the implementing acts adopted, which are basically the technical rules which will be defined and the practical arrangements regarding that. In March 2029, we have the first application phase for the primary use, and where the priority data sets within the primary use of data will be implemented, which includes patient records, e-prescriptions and dispensing, and initial cross-border data exchanges will also begin along with this application phase. Then in March 2031, we have the extended application phase, where EHDS will be expanded to additional data categories within the primary use as well, which are medical images, laboratory results, and hospital discharge reports. Under the secondary use timeline, this starts a bit later because the priority is first to implement all the application under primary use. So first deadline is in March 2029, where the EHDS regulation comes into force regarding secondary use. Then there is the expanded phase for secondary use, which includes additional health data categories. Example, genomic data, which will get open to secondary use. And in 2035, which is which is 9 years later now, the international collaboration phase will begin, where third countries and international bodies may join the health data at EU, which is like huge level cross cultural collaboration in health data. The key actors that need to be noted to understand the framework of EHDS are the data subject, data holder, data user, and health data access body. So data subject is basically the patient whose electronic health data is being processed. Data holder is the entity that holds the health data, which could be a hospital, lab, registry, even a wellness app. A data user is the entity requesting for the data for secondary use. This could be policymakers, researchers, companies, pharmaceutical companies, etc. And health data access body, which is the main actor facilitating this entire process of data exchange. It's the national body that receives and assesses requests and issues permits or data access for secondary use. So this is basically appointed separately by each country within the EU. So what happens really is that the data user gives a request for secondary data. it goes to the health data access body, who makes the data ready to be shared after taking it from the data holder. And the data is like, and the person who the data belongs to is the data subject, to put it in short. But this is just regarding the secondary data. Regarding the primary data, the data holder is the one keeping the data, which could be used in the future, and the patient can already access the data and reap all the benefits out of it, which we will come to later. So now coming to health data uses, what is primary use really? This is what basically something that assists in the entire healthcare process for the patients. This includes treating the patients, prescribing them medicines, imaging for diagnosis, anything that is diagnostical, even including social security, administrative services, etc., because they directly deal with the healthcare framework, and the benefits of this are reaped by the patient. When it comes to the secondary use, these are the purposes that benefit the society. The whole system is made in a way such that it benefits the society in research and innovation, in policy making, in healthcare system planning, regulatory activities, public health surveillance. So if you see this entire diagram, all of these actors come into place and create electronic health data. And there is sharing between these, firstly for primary uses, which is implemented as soon as 2027. Now this implementation starts then, and then the secondary use of the data will start as soon as the first things are in place. The highlights of the primary use is basically enhancing patients' rights, and this is supported by electronic health registries systems and the wellness apps. Basically all the EHRs, the EHRs and wellness apps have their own compliances, which are meant to support and enhance patient rights. Now, the patient rights could include the rights of access, control, and this is all in addition to the GDPR rights. Now, the wellness apps, which are the ones which transmit the electronic health data to medical systems, they have to be compliant with EHTS security and governance requirements as well for the whole system to work. And then electronic health record systems, which are also intended for healthcare providers to procure the data and store it in, they must also implement interoperability, security, and compliance standards, which is all under the EHDS, meant to support the patients. Now, giving an example of the secondary use. So I will use a European Commission funded project called Lucia, which has the aim to constitute a toolbox for discovering and understanding new risk factors that contribute to lung cancer development. Now to just it looks like a complicated diagram, but we'll understand it at a very high level. What really happens is that data comes through the Lucia system from various sources. It could be structured databases, it could be prospective data collection, open banks, and then it goes through some levels of processing through data models, computational models, machine learning classifications, becomes more structured such that it is ready to be put into an AI system. And eventually, as an output of this entire exercise, there's a toolbox that is created which encapsulates all the factors that may cause lung cancer. So this is basically a use with what secondary use of data basically means. It is not directly for healthcare, but it is for a research purpose, which can enable in development of something like this toolbox. And the data sources of this entire toolbox could be, like, at least in the EU, for instance, in Lucia, it's in Spain, Belgium, and Latvia. So all the data comes together to create a research base. So to make it very simple, how does the secondary use framework work under the European health data space? So the user investigates whether data which is required for the research is available in the EU metadata catalog. So for instance, in all these European projects, it's mandatory for you to share the metadata of all the research so that it's readily available. Then depending on the requirement, the user submits the application for a data permit to a health data access body, which is the body we learned about regarding which facilitates the entire process basically. Then the HDAB prepares the data, de-identifies it most importantly, so that there are no GDPR, so that there are no GDPR is complied with essentially, and prepares the data. And then user performs the data analysis in a secure processing environment, which is also provided by the HDAB, so that the data is entirely secure. And then the user publishes the results mentioning the data source and informs the HDAB about it. So like you can see, the health data access body is the body facilitating the entire process and ensuring that the actors from both sides are complying, and the benefits are reaped by the researchers in this example, for instance. So yes, holders are required to share the data with researchers, which also includes competitors and even authorities. They should map their electronic health data and implement internal processes for making it available. And even companies like pharmaceutical companies may also apply depending on eligibility for research and diverse sources. So this is supposed to bring actors from both sides together. I'll quickly finish with just the key takeaways from this presentation. So, as we discussed, this is a EU-wide framework governing both primary and secondary use of electronic health data. Two very separate things, but both very beneficial for the entire system. It introduces a new data governance model, and it's not just compliance rules, it basically gives operational health data sector rules. It's not a compliance mechanism, but a framework which is supposed to bring together all the data and facilitating transfer, which is compliant with GDPR as well. It emphasizes heavily on the secondary use and ensures there is cross-border access for research, innovation, and public policy, which is amazing in today's environment, because there were issues of access for researchers. There were a lot of hurdles when it came to compliances that needed to be followed, and there was no structure before. Some nation states had their own structure, but it was not implemented that well, and the whole development was very staggered. So this is quite revolutionary in that sense. The ambition is to create a framework which encompasses compliance as well as promotes innovation. But we will see how the implementation takes place, considering a lot of rule implementation is on the nation states, and a lot of it also depends on technical readiness, for instance, for providing a secure data processing environment, and how fast the states are able to act and develop health data access bodies, and also ensuring that these health data access bodies are not overburdened, because a lot of it is honestly in their hands, and the fear is that the implementation might be not harmonized, considering every nation state has different capabilities. But all of this is yet to be seen. But as far as the content of the idea and the ambition of the regulation is concerned, I think it's right on point. I will stop sharing here and quickly go to Sarah, so that she can start her presentation on Brazil. Thank you.
Thank you very much, Anushka, for the kind introduction. I'm very pleased to be here with you all today. I hope you can hear me well. As I lead corporate governance at Grupo Fleury in Brazil, I believe it is important to point out that Grupo Fleury is one of Latin America's leading diagnostic medicine companies. We're celebrating our 100th anniversary this year. So we have a century of patient trusts, which gives us a unique perspective on what makes healthcare innovation truly sustainable. Fun fact here, Fleury was one of the first diagnostic companies to give patient results online in the 90s. So healthcare innovation has been running in our veins ever since our foundation. I've spent my whole career at the intersection where innovation meets responsibility, implementing data protection frameworks while enabling digital transformation. As I've managed cybersecurity incidents in Now I'm supporting board level governance for a publicly traded healthcare organization in Brazil. What I've learned during this time, especially from an institution that builds trust over 100 years, is that the question is not whether we can innovate responsibly with health data. It is whether we're willing to build the infrastructure that makes innovation sustainable across generations, not just the quarters. So today, I'd like to challenge a common assumption that privacy and innovation are in tension, that we must choose between moving fast and protecting patients. In practice, strong governance frameworks don't slow down innovation, they enable it. Poorly designed governance truly slows down innovation. Organizations leading healthcare innovation in 2026 aren't those choosing speed over privacy or privacy over speed. They're building what I can call trust infrastructure, which is a systematic approach that delivers both simultaneously. So today, I'd like to share 3 practical insights from our work. First, privacy by design accelerates projects when integrated from day one rather than bolted on at the end. This is very similar to what our colleagues told us in the last panel. Second, governance for velocity, risk-based frameworks with clear timelines and empowered decision makers moves faster than traditional gatekeeping while maintaining appropriate oversight. And third, trust infrastructure beats compliance. Legal permission isn't enough. We need social license, patients who believe we're acting in their best interest and will continue sharing their data because they trust the companies. In healthcare, we're not just managing data, we're managing people's most intimate information during their most vulnerable moments. Governance frameworks we build today should determine not just whether we can innovate, but whether patients will trust us enough to participate in that innovation truly. The revolution in healthcare data is indeed coming. I believe that, honestly. And we need to make sure it's built on foundations that last and not just for this year or next year. So the key here is rejecting the premise that privacy and innovation conflict. They don't. When frameworks are properly designed, at Floaty, we use 3 main approaches that have evolved over our 100 years of experience, adapted for the digital age. I believe we can move on to the next slide. Perfect. Oh, it was the former. Thank you. First, integration from day one, when we can evaluate AI diagnostic tools, digital health initiatives, data protection requirements as the initial RFP, not added review. We cannot leave legal to be the main responsible people for compliance. We need to have compliance throughout the whole contract negotiation process. This actually accelerates timelines because we eliminate non-compliance vendors early. We don't waste months negotiating only to uncover fundamental conflicts with privacy laws or AI regulations. So we gain efficiency and we don't treat it like a burden. Second, governance for velocity. We use risk-based frameworks with clear timelines. Low-risk innovations get streamlined approval in 5 to 7 days. Medium-risk projects go to cross-functional committees with a 15-day SLA, and high risk goes to board committees, maximum 30 days. This critical shift committees ask, how can we enable safety? and not only if we should allow this. The mindset change for the executives as well in IT and in business has fundamentally altered our innovation speed. And third, our cross-functional collaboration from the start with legal, technical, medical teams all work together, and business teams as well, from project inception rather than sequentially. So privacy and AI governance becomes a design parameter and not a barrier. Our data scientists now think about data minimization and federated learning as technical challenges to solve, not only compliance obstacles. So the answer here is we need to integrate early and govern appropriate speed based on risk and make it collaborative. Privacy frameworks enable innovation when they're designed to do exactly that and not only to check boxes. And here I'd like to talk a little bit about how Brazil and the global community can learn from each other. What the global community might learn from Brazil regarding privacy and innovation is that the integration of public-private healthcare governance in Brazil is our biggest challenge, because we have SUS, which is an acronym, SUS, for our public healthcare system. And we have millions of Brazilians being treated by SUS alongside a robust private healthcare. This complexity has forced us to think systematically about data interoperability and governance frameworks that work across sectors. As other countries move forward toward integrated healthcare systems, Brazil's experience offers practical lessons. Implementation, pragmatism, and emerging markets. LGPD, which is our data privacy law, came into force in 2021. So we're implementing a modern privacy framework, but we have the advantage of institutions with deep patient relationships, such as Fleury with our 100 years of trust. It gives us credibility to implement privacy by design approaches that newer organizations might struggle with. We can balance innovation with institutional wisdom about what patients actually value, a collaborative regulatory approach as well. ANPD has been relatively collaborative while working with the industry, and it has not been purely punitive enforcement. We have had direct engagement with the Data Protection Authority in Brazil, and it has helped us during incident responses, and they understand innovation and protection can coexist. On the other side, what Brazil can learn from the global community. We can learn a lot, honestly, especially from Europe, since GDPR's implementation has given years of practical experience to draw from. We need to learn from Europe about harmonization. Brazilian healthcare systems is increasingly collaborative with international players. And sometimes privacy frameworks conflict, and it makes unnecessarily difficult to align. So the more aligned we are on principles, adequacy decisions, standard clauses, the easier advancing global privacy and medical science becomes. So the broader point here is that healthcare data it needs to respect the patients and not only borders. Diseases are global, research is collaborative. We need frameworks that enable this while protecting individuals. And Brazil brings an emerging market perspective, but also the wisdom of centenarian healthcare institutions that understand what makes trust sustainable. That's my final point here, Anushka. Thank you very much.
Thank you so much, Sarah. I really like the way you emphasized on building patient trust as the main focus of the entire system, and I think we definitely have a lot to learn from Brazil. Now we will go to Mariela, who would now enlighten us on the developments in Panama, and then we'll get into questions. Thank you.
Hi, hello everybody. This is morning here in Panama. Thank you, Anushka and Sarah, for joining me today and to privacy rules. My name is Mariela de la Guardia. I am González Ruiz and Alemán, and as Grupo Fury, y Casa González Ruiz Alemán is also a centenary firm. We just turned 106 years old last week, and we celebrated greatly with our partners and clients and providers. So today I'm going to talk more on the bridging the regional digital gap in health, AI, and data protection in Panama. Recently, I heard that in Panama, the health data of patients are being sold for $2,000 in the black market. This is extremely dangerous, and many people will say, "Oh, why? Why is dangerous? Because my data will be changed for diagnosis." I know, but if you give this data to a person who is in the organ donors, organ traffic, you think that twice, right? So Panama has four main legislations frameworks for the protection of data. The first one is the national constitution that provides the rights of access to the personal information and provides purpose. If the treatment of data does not have purpose, the patient will say, "Hey, I need," or the personal, the subject of the data has the right to request the cancellation of that data. The other recent, or well, it's not recent, but for us it's recent because it entered into force in 2021, is the Law 81 of 2019. This is the data protection law for Panama. It has all the principles, the sanctions, the rights that many of us know, and then the executive decree that regulates Law 81. In Panama, we also have, and this one is earlier than the data protection law, the general law of Panama is the patients' rights law. That's Law 68 of 2003. And this one provides the patients to have right and informed information of their condition. They have the right to confidentiality and privacy. They have they can be protected on the clinical data and autonomy of their data. And they have the right to be informed of their treatment and to decide, right? We can go on the next slide. Panama has launched a national strategy on health and in the health sector for AI and treatment of the data. This is a strategy for the years 2025 and 2030. This digital transformation is focused on integrating telemedicine, AI, analyzing the data and the analytics, and provide these services to reach the population that does not have access to medicine. And in Panama, we have many remote people who live in the rural areas. So this initiative seeks to improve internal processes, to know the diagnosis and to have a more efficient and efficient and effective health services for our patients in Panama. Um, this strategy aims to include technologies, to include to empower the patients in the clinical decision making. This also is collaborative for the sector, public sector, and the private sector, to build a more efficient and sustainable patient-centered system. Um, Also, this strategy looks for data audit. Panama wants to know what data we have. The data, as we know, has to be correct. The data has to be valid. It has to have consent, because health data in Panama needs to be as a sensitive data requires explicit consent. And particularly, there are 4 strategic goals: data management and information technology, governance and management, knowledge exchange management, and innovation. Some of the results that the data management and information technology are looking for are the resources, the quality of the data, the IT infrastructure, data governance, and standards and interoperability between all of these. And for governance and management is the strategic operative plans, leadership cooperation, human resources, and multi-sectorial collaboration, not only in the health sector, between commercial, technology, legal, and many other sectors. As mentioned, knowledge exchange management includes as the results that are looking for processes, knowledge architecture, digital health, scientific and academic community, and media and strategic communication. And for the last goal, innovation is preparedness and resilience, open governance, digital treatment, digital health, and health analysis for the decision making on the diagnosis. Panama is, well, we have this framework, legal framework. We are, as a country, determining the laws, decrees, regulations for the use of TICs, so we can all have a common framework for the exchange of information. Listening to Anushka and Sara, a word that has been mentioned is trust. Panama has a strong legal framework that increases trust. This is an opportunity, of course, with an ethical framework. We have the position to serve as a hub for responsible AI, but it comes with risks. Having a protective model can delay the training of AI and can slower the integration of the health data with the AI and digitalization of all this information. No? And some operative hurdles can happen, of course, and in Panama, and as in many other countries, the infrastructure is very difficult to have it in all parts of the country, as internet does not get to every rural area. I have to mention very important regarding cross-border transfer of data in Panama. Panama has lists certain conditions for the data to be allowed. Some conditions must be met to provide this data to other countries. One is to have a degree of protection in the other country for personal data. If I want to send data to Brazil, I need Brazil to have a protection equivalent or higher than Panama, and the responsible party offers or provides an adequate warranties. Also, if I have consent of the patient, I can transfer the data. But Article 51 of the executive decree indicates the following: the necessary data for the prevention of medical diagnosis, provision of healthcare, medical treatment, or management of health services. This is a condition that can be met to send data cross border regarding health information. These are some of the most important things that I can share with you. Of course, we have many technological, uneven technological capacity here in Panama and as many other countries. And of course, we have to be compliant with what the law requires, such as recommends for the private sector data protection officer, but for the public is mandatory. It's important also for compliance to have transfer protocols, processing of records, and to have incident reporting mechanisms. I think I've covered more or less my Panamanian uh, comments on the digital gap in AI, health and AI. Mhm. I can go back with.
Thank you.
Thank you.
Thank you so much, Mariela. This was really very enriching and gave us a good glimpse of the systems existing in Panama. So I'll start with the questions. My first question is actually to you. What practical compliance challenges do you think the companies and organizations face while applying the principles of loyalty, proportionality, and purpose, which were enshrined in the law, as you mentioned? Because we know these principles exist, but it's very difficult, especially in the sector of health, to really comply with them. What are the practical challenges?
Yeah, our constitution, law 81 and law 68 that governs patients impose strict requirements on how organizations can collect, process, and treat safely the data. It's vital to have first quality of the data, but what these organizations can do is always require the consent of the patient. I remember a couple of years ago, I had surgery, an emergency surgery, and as a lawyer with knowledge in data protection, I had to take the contract of the hospital and I have to insert myself some clauses, such as the medical team cannot use tweet photos for marketing for their social media, for example. They cannot take pictures for without my consent for anything else than they cannot do this. So a lot of people are not aware of their data and how it's used. And as organizations, you have to ensure that the health data that you have is the minimum necessary uh, for the treatment. Uh, but as long as you have the consent of the patient, I believe you are good. Now, as I mentioned, if it's necessary for the treatment for a diagnosis, you can transfer it. For example, if you have a patient with an exam that cannot be read in Panama, you can send it to the United States for the purpose of other colleagues there to read the exams and the MRIs or whatever. But yeah, it's complex, but if you have consent of the patient, you can collect, process, and maintain the safe of the data, right?
Yeah.
Yeah, It's complex, but can be done.
Thank you, Mariela. And yes, indeed, consent is the starting point of the entire journey of the data here. My next question is to Sarah. So, as Mariela mentioned, consent is the starting point. And this is something that absolutely builds trust in the patients. But do you think, as far as Brazil is concerned, there's any difference between building this trust and compliance? Are the compliance measures actually able to build the trust in patients, or not? Like, what do you think? I can't hear you, Sarah. Mariela, can you hear Sarah, or is
I cannot hear Sarah.
yeah, we cannot hear you, Sarah. No, not at all.
No.
Still no. While Sarah fixes this, Mariela, can I ask you another question just because we have
Yeah, of
minimal
course.
time left for the panels? Um, what is like, how does Panama's approach to cross-border data transfer compares with other regional frameworks? And what risks and opportunities does this create for international health and collaborations? This was also a
Mhm.
question we were asked by the audience, something related to how countries are now trying to streamline like some kind of like data within their national states, because that they think that is the safest because they can apply their own laws. But
Mhm.
keeping this in mind, how do you think cross border data collaboration can still be safely done?
Yeah. Panama cross-border transfers are more aligned with the European model, which emphasizes in consent, purpose, and strong safeguards for international transfer that in Panama, for as I mentioned, is protected. Uh, Article 51, mentioned before, requires some conditions to be met. One is consent, but it's not that you need consent and other conditions. You have to just meet one consent, one condition, uh, which is if I transfer the data to a country that provides a higher degree of equivalent or higher security protection, when the for example, if is for a purpose of prevention of a medical diagnosis, provision of health care, medical treatment. If, for example, if you have consent, it doesn't have to be all these conditions. If you have one condition met, you can transfer the data to other countries. Yeah,
Yeah,
that's
and since health data is more sensitive than other kinds of data, so these conditions are also very strict. And at
mhm.
least in EU, there are very strict safeguards regarding what can be transferred and which countries it can be transferred to as well. There are various means, but it has to be very in a secure environment. And I understand why countries are trying to secure and keep their citizens' data within the countries itself. But like for health data specifically, like you mentioned, not every healthcare system is that sophisticated. So we might have to send patient data to another country for better healthcare, and most importantly for research as well. Cross-border collaboration is essential in light of all the developments with AI in the health sector. And the more data we have, the better results can happen. Like I mentioned in the European projects as well, there are times when for clinical trials and everything, we get data from all over. And of course, it's safeguarded, it's anonymized wherever possible. And all the safeguards are in place to ensure that the purposes are fulfilled, but at no point is patients uh, like there is any disrespect to patients' data, or is there any risk to their privacy. Sarah, can you try speaking so that
think you'll be able to hear me now. Can you hear me?
yes, perfect.
Great.
Is
I'm
it
so
is it
sorry
possible
for the
for you?
technical
No
problems.
worries, no worries at all. We would like love to hear from you on the question that I asked, which is, I think, very critical about whether compliance is able to get at the level where you feel that there is trust built by for the patients.
Right. I don't believe, honestly, that compliance alone can fulfill the gaps and enable innovation. I believe we need integration, and also we need to have business teams who are aware of what governance can bring to the table. So what we do on a day-to-day basis is practice awareness of where we're going. Why do we want to innovate? Why do we want to use patient data for innovation? And with this awareness, we use transparency as a key term, not only internally for our internal stakeholders, but also for patients and parents and responsible adults. And so that's our key term. We use transparency and awareness to build trust. I believe that when we have integrated teams who know where they're going and why they're doing this, especially in the healthcare system, we are able to solve any problems that may and do come up when we're dealing with innovation in healthcare data.
Absolutely. This makes complete sense as long as I think Mariella emphasized on consent, but I think consent also comes with after there's absolute transparency about what will be done with the data. And it's very different if the data is being sent for diagnostic purposes, for research purposes, or marketing purposes. So there needs to be absolute transparency to what extent the data will be shared and for what purposes will be shared. And at all times organizations should maintain minimization, so that it's only when it's necessary that something as sensitive as health data of a patient is being shared. And this is, I think, no matter what we say, that okay, countries are trying to safeguard their own citizens, and every country is at different level infrastructurally and even law wise. But if the basic principles are followed, which are pretty much international at this point, I feel we can go, like we can have a longer road ahead. But I think we can go very far in ensuring cross-border collaboration as well. And I think this is what countries are trying to do, especially with the adequacy decisions and standard contractual terms, so that there is more data available for research as well. And I think this is a good note to end. We are delayed by 5 minutes. Apologies for taking up the break, but I think we had a good session, and this seems like a nice note to end this on, unless any of you have anything to add. Okay, back to you, Alessandro.
I was happy to leave any other note, but thanks a lot to you all, and of course, no need to apologize. I believe it was an extremely interesting session. Of course, the counter side of having short session with presentation, that you make meaningful presentation and that you have short time to discuss them. I think we were just warming up into the discussion. So hopefully we will take this session as the leading point for new sessions or activities in the future together. But I'd like to thank you all for being with us. Before moving to a little break of 4 or 5 minutes, we will start in 10 minutes from now. So we have time for a coffee. And we see each other together with the next session that will be on artificial intelligence and fintech. We will discuss about risk management, compliance, and strategic readiness with another panel of experts coming from very different areas of the world. So looking forward to seeing you all in our upcoming session. For now, I will leave you with a brief video, and then we reconnect at 45. So in about less than 10 minutes from now.
Updating privacy policies across multiple countries shouldn't feel impossible. But with regulations evolving constantly, new requirements emerging every month, and each jurisdiction demanding something different. Even the simplest policy update becomes slow, fragmented, and costly. Most organizations spend weeks, even months, trying to align global policies, only to end up with inconsistent documents that fail to meet local expectations. When compliance becomes unclear, risk increases. The Privacy Rules Global Policy Revision Service solves this challenge. We deliver a coordinated, cross-border methodology that adapts to any sector, including fast-moving, AI-driven industries, where regulations are changing faster than ever. Our global experts collaborate to ensure every policy update is accurate, aligned, and fully compliant with local laws. No more conflicting versions. No more overload for your internal teams. Just clear, consistent, globally harmonized policies delivered efficiently. We streamline the entire process. Flexible coordination across jurisdictions, centralized invoicing, shared workspaces for seamless version control, and strict confidentiality at every stage. Everything you need to revise policies efficiently, all in one coordinated service. Privacy Rules, your global partner for seamless cross-border policy compliance. Simplify your global policy revisions. Contact us today.
Okay, I think we are back. I think you could enjoy a little coffee break after two very insightful questions with many topics and a lot of discussion. So I hope you are not too tired because we have two more sessions and the next one sounds really interesting. I first of all would like to invite to join me the moderator of the session, which is Janet Otero from the law firm Cavendish, based in Kenya and member of the Privacy Rules Alliance. So, Janet, thanks a lot for being with us today and for accepting to moderate this session. I'm really pleased about it because this is a very relevant topic. We even spoke about it in our last event of 2025, that in that case with a more deep focus on Latin America. This time we are going to have a more global or multi-jurisdictional overview. So, Janet, I leave the floor to you for the introduction, and I thank all the speakers for this session.
Thank you, Alessandro. Depending on where you are, good morning, good afternoon, and good evening. My name is Janet. I'm an advocate practicing in Nairobi, the law firm known as Cavendish, where we support clients in the TDFI sector, that's tech, telecom, data, fintech, and innovation. And my speakers today, or my panelists today, there's gender parity, thank goodness for that. So I'll have Munib Imran Shaikh. Munib is an information security and a data privacy practitioner, as well as an AI governance consultant. He is based in the Middle East region, so it will be good to get insights from him from that particular region, and has worked or has supported clients who are smack in the financial and telecommunication sector, but also governmental agencies in helping them develop and implement cybersecurity and privacy programs. And these are all customized towards their regulatory and legal as well as compliance requirements. He's written various papers, published various papers. He's an active podcaster.
I think there has been a little issue with Janet that we are missing. So let's check if she's coming back. Apologize for the inconvenience. And let's reconnect in 1 minute just to make sure everything is good. Sorry for the issue. Okay, I see Janet back, so I'll leave her the floor again. I see that
Sorry.
also Munib. No worries, Janet. And
So
sorry
it lost me.
interrupted you half the way.
Okay. So I was just introducing Munib. I don't know if he's managed to fix his camera. As he's doing that and coming online, we'll also be joined by Kate Moody, a lawyer at FBT Gibbons in America. Kate is an associate in the data, digital assets, and technology practice area. Her areas of expertise focus on aiding companies within the digital asset, fintech, and payment spaces comply with any regulatory and contractual concerns. Apart from that, Kate has experience in end-to-end support of drafting technologically related agreements such as licensing, software development, subscription, and SaaS agreements. In addition to that, Kate is currently undertaking drafting agreements for digital token and cryptocurrency companies. So we'll be looking forward to your insights from that financial technology sector. Munib, are you online? As we wait for Munib to come online, maybe Kate, I can open the discussions with you. AI has become the topic of the day. AI in the house, AI in the office, AI in the streets, AI everywhere. And we're looking at a lot of financial institutions and fintech companies leveraging on AI for their offerings, whether it's to do credit checks, whether it's to do asset management, whether it's to do KYC and suspicious transaction monitoring. So when a fintech or a financial institution, such as the ones you work with, is looking to leverage on these tools, from a privacy aspect, what would a privacy and privacy compliance officer would be looking at in terms of what are the cons and how to mitigate some of these issues that arise?
Thanks for your question, Janet. Like she mentioned, I am in the Dallas, Texas office of FPT Gibbons in the Data, Digital Asset, and Technology Practice Group. And before I jump into the meat of this question, I want to start by saying that a lot of my answers today can probably be summed up as new tools but old rules. At least in the United States, there isn't an omnibus or a single point of law that governs the use of AI in the fintech industry. Compliance is going to be dependent on the various existing frameworks. So that can look like, consumer protection rules, financial industry or sectoral rules, or state privacy laws. So that means that compliance is really going to come down to industry or sector specific rules, and those specifically geared towards consumer protection, which is, I think, a hot button topic right now. And so just to touch on two of those examples, one old rule with new application considerations, and then a second, which is a new rule geared towards mitigating potential harms. First, I'm going to dive into the Federal Trade Commission's Gramm-Leach-Bliley Act in the United States, GLBA, and that provides a framework for regulating the privacy and data security practices of a broad range of financial institutions to protect customer information, particularly like the safeguards rule. That helps financial institutions report to the FTC any notification event where unencrypted customer information involving 500 consumers or more, they need to notify within 30 days. And that can look like unauthorized access as well. That counts as acquisition of unencrypted customer information in the US. And so practically speaking, fintech companies, whether they're the financial institution themselves or operating as a vendor or a service provider, they should really consider the obligations when experimenting with these AI tools. So that looks like retaining service providers that are capable of maintaining those appropriate safeguards, requiring that through contract. So setting up your agreements with your vendors or your financial institutions to allocate risk about, when things go wrong. And then also assessing and monitoring service providers, because we should all recognize that even though we are contracting to allocate risk, it doesn't mean that you're not going to be, held liable by a regulatory body. And so then moving on to another consideration would be the California Consumer Privacy Act's newly implemented regulations about automated decision-making technology. And so you kind of hinted on this, Janet, when you talked about credit decisioning, credit unworthiness decisions in the United States, and how personal information is used to make those decisions. And this is a new set of statutes in the CCPA that is really rolling out in deadlines and going to be forced to comply with either, if you already had these programs in place by January 1st of 2027, or going into the future at launch after that date if you are a new fintech company in the space. And that's just geared to saying that, hey, decision that affects significant issues like lending services, housing, education enrollment opportunities, employment, other independent contracting, or compensation issues, those need to have human oversight involved to make sure that bias and discrimination are not kind of seeping into the process there with AI tools, recognizing that, AI can make things go faster. It can make things innovative and nice to use, but also wanting to make sure that those consumer harms are still mitigated as we roll that out.
Thank you. Brilliant. That's quite interesting. And I like what you said, new tools, old rules. So, and that's the truth for a lot of jurisdictions. We are really relying on the mechanisms and the framework that's there, other than Europe, which might have an AI Act that may not go into specificities in such an areas, but it's a good start. And you see, as we're talking about new tools and old rules, Munib, as a DPO or somebody supporting DPO functions. We've already discussed with Kate how AI is becoming adopted as part of our day-to-day life processes. And like Caitlin has said, AI, while it has its pros, it also has its cons. But even in just leveraging and deploying these tools, there's a lot of data that goes into them to be able to make them achieve optimization. So as a DPO, what would be your main concerns when it comes to this increased desire for AI adoption in certain organizations, in most organizations?
So, first of all, thank you so much, and I apologize for the minor hiccup. The thing is that, see, the DPOs are supposed to be the ambassadors of the individual rights, and they are supposed to safeguard those individual rights and the freedoms within any organization. So whatever organizational pursuits are, they are supposed to be, they should not come at the cost of impinging upon the fundamental rights of the individuals or the freedoms or their interests. So again, the fuel for, or the fundamental ingredient for AI is actually the data. And it's just that that data is being processed by automated means, and you are reaching out to certain conclusions by virtue of the AI. So when you are having these organizational pursuits, obviously for the value creation, that the business sees some kind of value in going after those initiatives or those ventures. Now, how do those pursuits impact the fundamental rights of the individuals? That is where the DPO role comes in, and this is where the DPOs have to see that how the rights of the individuals are going to be safeguarded.
Thank you, brilliant. And I totally agree. At the end of the day, all these tools and all these services we offer is towards consumers, and if we continue prejudicing and putting our consumers in a position where they're not comfortable with how we are using their data, how we are processing their data, then we lose out on the consumer base, in addition to attracting other bad reputational crises or bad penalties. So back to you, Caitlin. Within the virtual assets and digital assets space, like Muniba said, most of these tools, and as a DPO is concerned, would be fundamentally about protecting data subject fundamental rights. But like we've said, AI can be biased and can be very skewed or can present errors, especially if you're going to be using AI tools for investment in digital asset space, where you're using it for predictive analytics, portfolio management. What would be some of the data governance or the privacy considerations that you'd be able to put in place for these tools to prevent a bias or cause harm to the consumer?
Yeah, thanks, Janet. So I think that, not to be too repetitive about my last answer, but it's kind of similar. There are new tools, but old rules. And so if an AI tool is involved in, doing predictive models for trading, investment signals, portfolio optimization, all of those things, if they are considered, a broker-dealer, investment advisor, and subject to SEC regulation, one rule that can come to play is Reg SP. And so if it doesn't, fall into those frameworks, it's also going to be potentially subject to GLIBA, like I mentioned, or other privacy frameworks like state privacy laws. So it isn't just sector specific. There can be fallbacks, and there's lots of ways to grab these tools into the regulatory landscape and that they can face enforcement. And for example, Reg SP would require covered institutions to maintain a written incident response program or to notify affected individuals within 30 days when sensitive customer information is, released without authorization. And then this amendments that I think happened fairly recently, they also tighten service provider oversight and record keeping, much like other updates to rules and from the Federal Trade Commission that I think tighten as well record keeping and oversight rules. So it's basically regulators coming out with the attitude and saying, hey, just because there's these new rules, it doesn't mean that you're going to be absolved, especially just by kicking the can down to the service provider and allocating that risk through contract. And so I think the important consideration is just to make sure that incident response covers your data flow for whatever AI tool it is. Service provider management, making sure that that's tightened up through contract, and then as well as just ongoing relationships with your service providers. And then, yeah, just making sure that you are doing all of the things to safeguard consumer information, I think is the bottom line. Oh, I don't think we can hear you, Janet.
Can you hear me?
Yes.
Okay, the host had unmuted me, and I agree. I totally agree. I mean, while you might have your internal safeguards in place, you might have your organizational safeguards in place. You are collaborating, or you are integrating, or you are partnering with third-party providers who will also present the same risk or much larger risk if they go unchecked and uncontrolled. And Munib, to speak or to build onto that point, third-party risk is one of those issues every DPO is usually wary of and very concerned at managing because they are an exposure to any organization. So what other areas do you think can significantly derail adoption of AI within any organization, seeing that you've worked with telcos and fintechs and also governmental bodies? What would you say are other areas that you see that can slow down the adoption or can impact the deployment of AI in any organization?
So see, it all depends upon the existing maturity level of the organization in itself. How organization is mature in the functions that have established, that have been there for 2 to 3 decades. Now, AI ethics and AI governance, they are relatively new disciplines. Even privacy is a new discipline. But an organization that is still struggling with the established disciplines like related to data management or the ones related to cybersecurity or IT, they are, I mean, it becomes extremely difficult for them to actually embark upon the journey for AI adoption. Yes, the management has this desire in the organizations to basically, lurk upon the opportunities to have the AI, incorporated, however, the thing is that it all goes back to the fundamentals. How strong fundamentals are there within the organization? How strong data management fundamentals are there? How any engineering life cycle is being executed within an organization? Because if the engineering life cycle is broken, then even any application which is being developed, it's not going to be secure, it's not going to protect the rights of the individuals, firstly. Now the same kind of hygiene is going to be reflected even into your AI adoption journey as well. So which means that you will be doing a lot of things on the fly, you'll be doing a lot of things in a rather ad hoc manner. So, but again, the thing is that all your pursuits which were effectively there to create some kind of a value, those things will not last for long. So these are some of the things that are extremely important. The other thing is that there has to be a clarity around why an organization is embarking upon the journey to adopt AI related solutions, or why does it want to have things move towards the AI? Does it really qualify to be a good use case for the AI or not? Because not everything that you want to basically move towards the AI infrastructure or the platforms, I mean, that also entails a lot of cost, and something that you only once in a year, and that is not really labor intensive. Not necessarily that these things could be a really good use case for the AI adoption as well. So again, it all boils down to the fundamentals that your organization has. One last thing that I feel that can significantly derail the AI adoption is that what if an organization is having certain pursuits with vis-a-vis AI adoption, and if those pursuits are completely disconnected with the aspirations of the board, Okay, these are the things that can significantly disrupt your journey towards AI adoption.
Thank you. Thank you, Munib. Absolutely true. I mean, a business strategy, any business that's leveraging on technology must have a strategy. And we all know strategy begins from the top to the bottom. So if your board has other strategies, if you're not aligned, then I mean, the culture of buy-in is basically lost from the word go. And again, within East Africa and within Kenya, we've seen a lot of sectors leveraging on AI. Initially as a test basis or for administrative functions, but we are seeing a lot of them embed them within their day-to-day operations, with the biggest being mobile network operators and fintechs, followed by financial institutions. And like Caitlin, you said, analyzing creditworthiness, suspicious transaction, KYC, and customer onboarding. But also we are seeing law firms and legal services also increase their uptake of AI, enabled to be offer its services. And we're also seeing the healthcare sector within a lot of East African countries adopting or leveraging on AI. But the most surprising one has to be government. Government agencies are now willing to tinker with AI for certain deliverable public services. And it's interesting to see how they will sector manage or sector regulate this in the absence of a national legislation, like Munib says, the absence of a national legislation to be able to govern them. Now, looking at how financial institutions and fintechs have been able to leverage on AI in most countries, Caitlin, this is now to you, smack in the middle of the fintech sector. Between the regulators and these financial institutions, how are they looking at dealing with AI tools, especially when it comes to decision making in the financial services? Are they speaking from the same book? Are their thoughts aligned? Are there conversations around this? Or are they speaking from different pages? Or are they speaking down to each other? Or are they speaking at each other without reaching any sort of a conclusion? What is the relationship between some of these financial institutions and the regulator in your area?
Yeah, so in the US, I feel like what I've seen in practice so far and kind of what I can speak to is that it's that same attitude, Janet, that I mentioned of it's old rules with new tools. And I don't think that regulators or the financial institutions are kind of approaching it either way. I think financial institutions, want to be in compliance. They want to make sure that they're not getting in trouble with any regulators. And so I think that drives kind of, hey, if regulators are signaling that old rules still apply, we're going to approach it in the same manner. And so one lens that I've seen this through in practice is through ECOA in the US, which is the Equal Credit Opportunity Act. And so there are different AI tools out there that are helping, credit underwriting processes, and doing different things like that that can help with credit decisioning. And when that happens, I feel like the regulators have signaled very clearly that new AI developments do not mean that you do not have to follow old regulations and your compliance requirements. And so this is meant to protect as a law discrimination against any applicant with respect to race, color, religion, national origin, sex, marital status, age, all of these protected classes in the United States. And so through contracting, I have seen different provisions, inserted into this to try to allocate risk in their agreements between financial institutions and AI-related vendors. And so I think if you're a vendor, it looks like including provisions in agreements that maybe disclaim reliance on outputs and representations and warranties that if this is used for decisioning, the financial institution is going to make sure that they're following, old obligations of, hey, we're going to say there was a human oversight in this. This is the very clear reason why we didn't give you maybe a positive decision in lending or in underwriting. And so I think that that's kind of it's indicative of the attitudes of both. I think they're talking and they're kind of, working together to say what do we need to do to be in compliance, especially in light of there not being one single AI law. And then another example as well would be the Federal Trade Commission action against Rite Aid, which they used biometric technology. And this wasn't a fintech, but they implemented biometric technology to kind of score individuals and, say, do people have have a risk of shoplifting or bad behavior in our stores. And so the FTC didn't like that. People weren't notified of their personal information, their biometric facial recognition being collected. And so I think carrying this over to fintech, it looks like if you are going to use these tools, you need to make sure that you have all of the appropriate disclosures in place. You need to be notifying individuals, giving them pre-use notices of all of these tools. And then if you are using a service provider, making sure, like I said earlier, that they are, following and saying what they're going to do in the contract, whether that's through auditing the service providers or managing them or having written policies, just to protect yourself from a financial institution perspective.
Thank you, Kate. Personal responsibility. Responsibility is a heavy pill most people are afraid of swallowing, but it must. And speaking of responsibility, Munib, and to go to your point about the organizational culture and just understanding what the organization wants from itself. When it comes to the responsibility of good data governance and good data management, is it does the buck stop with the DPO? Is it the responsibility of the DPO to carry the burden of good sound data governance and sound management? Can the board be held accountable? And where do the lines start for each other? Like we said, they must be having conversations with each other. So for the DPO, where does it start and end? For the board, where does it start and end? Especially when we are using AI systems, where does the line of responsibility with the privacy risks start for either the DPO or the board, and how can they align as well?
So it's quite a loaded question. Let me try to unpack this. Firstly, I think it's extremely important that AI adoption is not seen from the lens of technology. It's not just the technological solution that is being adopted, and it's rightly attributed as a socio-technical system. Actually, that this technology has an impact on the society. So firstly, if the board treats these affairs as merely instruments associated to technology or instruments for innovation, that in itself is something that requires a reckoning. The second thing is that I am not really sure how many DPOs even have the access, directly or indirectly, to the board. That's also very important. Now comes the third part, which is that where the responsibility for each party in this particular question, one being the board, the other one being the DPO, starts and ends. So eventually, for any pursuits, as I mentioned, for any organizational pursuits, board is the one that is accountable. They own the risk. They are the ones that actually drive the business strategy, and they are the ones who actually set the direction in which an organization is going to operate. However, the DPOs are merely the advisors. Now, they do derive their power from the organizational hierarchy, which could be coming from the chief executive and right down to the relevant chief to whom the DPO might be reporting to. If it's board or even if it's a chief executive, however, the thing is that the DPO is merely an advisor. However, they also have to work with the internal stakeholders to ensure that there is a risk culture that respects, that is sensitized to firstly identifying the risks associated with the individual harms, the group harms, the societal harms that can actually materialize because of certain organizational pursuits that are coming associated with AI, and even in terms of the environmental harms. Now, firstly, these things are extremely important for for an organization to be sensitized with. And then as far as the DPO is concerned, they have to make sure that if they have been given the power, they should utilize that power, that authority, to create a culture and also create a governance mechanism through which all these fundamental rights of the individuals, not only the individuals, but again, if they have also been given the responsibility to implement AI governance, these things should be well understood within the organization, and the risks associated with the personal data processing or the risks associated with the AI. Now, those risks could be the individual harms or the group harms, societal harms, or even the environmental harms. How those risks are going to be identified, handled, and how do you sensitize the business owners to act upon those risks. And if those things are not being acted upon, then are they being highlighted to the board? And what authority does the board has to basically enforce the mitigating actions around it? So that's how the relationship is going to be structured. But if I have to give a one short answer, again, DPOs continue to remain the advisors, and they are the ones who have to provide the necessary warning, the traffic lights. However, eventually the board is the party that owns all those risks, and they are the ones who carry the final accountability if certain risks really materialize.
Good. Thank you. Thank you for such a detailed answer. So we have some questions in the chat section, about 2 questions, which I will give the panelists 2 minutes each to see whether they're able to contribute to that one question before I answer. It's quite long, so I'll just jump to the tail end of the question. Can we actually build a compliant global AI model, or are we entering an era where AI must be rebuilt from scratch for every jurisdiction? I'll start with Caitlin, 2 minutes, Munib 2 minutes, and I can probably give an insight from an African context in 2 minutes. Are we
Yes.
able to build a global AI model, or must every AI be built from scratch for every jurisdiction?
Unfortunately, and maybe this is just my cynical US perspective, because everything here, it doesn't appear that there is, we have federal, we have state regulations in the US, so it's kind of already that way for us. So anytime somebody comes to us with an AI question, a fintech question even, or a privacy question, it's often deciding, okay, what federal rules apply, but also what state rules apply. So I think my answer may be unfairly influenced, but I'm thinking that it is kind of at a place right now where we are looking at it from a jurisdiction perspective. I don't know that it will be that way forever. I'm hopeful that maybe we'll one day see, at least in the US as well, broader privacy and AI regulation models that would make it much easier on US practitioners that are trying to help our clients navigate the regulatory landscape. But for now, I think my answer would be that it is still imperative to look at it from the laws that apply to you and that are triggered based on where you operate, what consumers you interact with, and things of that sort.
Munib?
Yeah, so just adding on to what Ketlin was saying, I feel that the foundations, the fundamental principles across all human societies, they remain the same. Again, it doesn't matter to which part of the world you belong to. And these AI systems are meant to embody the same universal principles on which there is a consensus, there has been a consensus across centuries. Okay. Now, however, what happens is that there are cultures, there are subcultures within cultures also. And laws are an instrument actually to codify those human values actually. Now the thing is that when the states become too large and they're too decentralized, at times what happens is that jurisdictions also have some kind of a power contestation amongst themselves actually. So the outcome that they all want to attain is perhaps the same, but the risks that are lurking in their mind are of varying nature basically, or of varying levels. So therefore they want to maintain that segregation, and they want to make sure that they are able to exercise the independence of their own jurisdiction. But I also see a practical point in this case is that, let's say if some kind of a harm materializes, and let's say if someone is based in Kenya, and if that citizen of Kenya wants to have the remedy, the first authority to which a Kenyan citizen would go to would be the authority within Kenya. They will never go to US or elsewhere in the Europe. So therefore the jurisdictions ought to maintain some kind of a power. Now, what the question that was raised, I still believe that it is pretty much a utopian idea, but I hope it is practical, or we can move closer to that.
I totally agree. I mean, in the same way, we don't have any universal law governing each country in terms of its internal operations and its national operations. It's very hard to find a product which can be used and scaled globally. And also, we also see the way a lot of entities cross over across jurisdictions. And even when they come to Africa, they have to change their outlook, they have to change some of their operational aspects, even some of their offerings, because that's not what is, like you said, culturally acceptable in the country. So in terms of even an AI tool that is globally used and accessed, it would have to follow the same format. The foundations and the basic plan can be the same globally, but in terms of deploying and use and experience, it would have to go country by country. So we might get there one day, but not anytime soon. So the other question that we normally get in terms of AI is a liability. Who does the liability lie with? And this is a common occurrence when it comes to deployment of AI services and AI tools. So where an AI agent, not a human being, makes a decision and it's biased, who will the regulator in your respective jurisdictions, who will the regulator fine for such a decision? So it's the DPO who may have checked the box, the board may have signed the check, and is it the DPO who actually initiated this process, the board who gave the final check? We are talking about a credit lending situation here. Or is it the vendor who sold the software to this financial institution? Who will the regulator be looking to penalize for such a prejudiced decision, credit decision? We can start in this order, Caitlin, then Munib.
Okay, so let me take this one first. I see it, and I'll take a leaf out of the book of the approach which is adopted by European Union AI Act, and they have very smartly created this distinction between a deployer, developer, and there is one more, I think, distributor, and there's one more. So again, I see it in at two layers, that the party or the entity that is actually providing such credit lending solution, or the application or the AI solution actually. Now, what were the fundamental design considerations that they took into account while designing that solution? If the fundamental design considerations are disadvantageous to a specific category or to a specific group of individuals, then the then the liability does sit with them. That's point A. However, if they have taken the ethical design perspectives into account, and they built an AI solution where which could have mitigated the individual harms, group harms at large when it comes to the credit lending. However, the entity that has basically onboarded such solution into their own ecosystem, now when they blended this AI system solution into their own ecosystem, they did not regard the ethical principles, or where they did not take into account the fundamental rights impact assessment that may have to be carried out in this case. Yes, they'll share the liability. Now, within the organization, if DPO was supposed to carry out all such assessments, and if the DPO did not exercise the necessary due diligence, then yes, the responsibility and the accountability is resting in this particular case with the DPOs. But eventually, the boards cannot get a free ride in this case. That they will be held accountable eventually in front of the regulators also. Catalin, what would you like to?
Yeah, I think we lost Janet for a second, so I will jump in and take the question. So in the US, I think kind of a perspective that may not be unique, but that I'm seeing more often, is that people are trying to contract about that liability. So between financial institutions and vendors that are giving them maybe AI tools, or fintech companies that are offering these products and services, you're going to try and deal with, okay, this is who's holding the risk. And that's like what I said earlier about, the financial institution is repping and warrantying that, they are doing the human decisioning check that's required by law. And all of these things are contractual liability, but it doesn't mean that you cannot or it doesn't mean that you can get around it and not fall subject to regulators on your own through individual liability. And so that can be Federal Trade Commission. I'm trying to think of different other governing bodies that are going to be looking at this, and it's all geared towards protecting consumer harm. And so the key takeaway there is just that regulators are approaching AI tools as falling within the scope of those existing regulations, and using complex algorithms for decision making. It's recognized that it is innovative, but at the same time, the same regulators are going to come knocking, I think, in the US if you are individually subject to those rules. And so I think that's kind of what you can expect. You can do your best to contract around it, to make sure that you're in a situation where it matches your risk tolerance, but it doesn't mean that it's going to work out the way that you want to at the end of the day, just because you hired a service provider, or just because as a service provider, you said that liability rests with the financial institution making that decision. Oh, we can't hear you, Janet.
Can you hear me now? Sorry, they they keep on muting me on the back. So from the African perspective, it's the same like what you have said. In the absence, we don't have AI, any country with an AI legislation as it is currently. A lot of piecemeal policies and strategies that exist, but no, there's no strict one legislation or regulatory framework. So like you said, you have to rely on the existing frameworks that are there on consumer protection, on pricing models, on how disclosures. With the regulators who work with these fintechs and financial institutions that offer these services, one of the requirements they usually want to see is how your back-end operations usually are structured, how you reach conclusions, and whether there's human intervention. And this is from a privacy perspective. So we have all these regulators working to make sure that if there's any bias or any reported harmful decision, regulator with regards to privacy is able to step in and see whether your automated processing has human intervention. The regulator to deal with the financial sector is able to look at your algorithms and your pricing models and your decision-making models to be able to see whether they're market compliant or not. And then we have the consumer protection agencies that are also able to give their input in terms of how you reach these decisions. So as a roundup, and finally to the beautiful session we've had 1 minute to 1.5 minutes each. Munib, I'd like to know your thoughts on data ownership. Where does data ownership, how do the issues related to that, and we all know data is now sitting on the asset side of a lot of balance sheets. So when it comes to data ownership, what is the impact of data ownership issues when it, as far as AI governance is concerned? And
I
even
think
data
privacy.
governance.
I think privacy is already, if there's something that is already hotly contested in the field of privacy, it's the identification of the data controllers and the processors. I mean, this is something that requires a very nuanced understanding within the privacy professionals. I foresee that this issue is going to become far more prominent when it comes to the AI governance, because the data ownership is not determined just by virtue of someone giving the data to another party. Again, you have to see the drivers behind why someone has actually given the data to another party. The second thing being that once the data is provided by entity A to entity B, what are the limitations? What are the processing limitations that entity B has to adhere to? The other thing is that, if that entity uses that kind of a data for any AI models training or something of that sort, again, how does the intellectual property, related matters really get activated? So again, this is a very complex matter, but I think the roots for this complexity do not lie in the AI ethics or the governance in itself. I think it emanates from the debate that still requires very thorough and nuanced understanding within the privacy professionals, that is around the data controllers and the processors. So based on my experience, what I've observed is that a lot of the regulatory or the legal instruments do not even identify the nature of relationship between the two entities as independent controllers and the joint controllers. Now, what happens is that those individuals who have never understood these things, or never seen things beyond their own regulatory instruments, it becomes extremely difficult for them to identify the ownership of that data. Now, they may say that, okay, since we are giving the data, we become the owners. The other party, since they are the recipient, they become the processors, and we remain the owners. But again, it's not as simple. I mean, it requires a lot of, and this is something that has huge ramifications for the business as well as you go on. I foresee that this is going to, further get. It's going to become far more prominent when it comes to the AI governance, and this is a topic that requires detailed discussion. Yeah.
Yeah, thank you for insight. You are right. Even from merge and acquisition sort of scenario, we are looking at data ownership as one of those things that are becoming quite contested assets when it comes to acquisitions and even transfer of assets between companies. Finally, Caitlin, data ownership is one of the contentious issues. What other steps can fintech companies take to just ensure practical data use if they're going to be deploying and leveraging on AI in their operations, especially where the AI is being supplied by third-party vendors? What are some of the practical steps that anybody in-house can be able to just put in place?
Yeah, I think this looks like treating all of your AI data flows as a part of your privacy and security programs, setting up incident response playbooks, and they need to account for the AI components that you're using. Like I mentioned earlier, the tightening of service provider governance. And if you're a service provider, I would argue that's in your interest too. And just the remembering that outsourcing doesn't equal offloading liability. And contracting with regulatory requirements in mind proactively. So if you are expected to meet certain notice or response times, making sure that in the contract that's set up for service providers and use a financial institution, or the other way around, if either of you have reporting obligations, making sure that the time periods within that contract make sense for that and match it. Not to forget, if you're operating in the US, to think through state law. We make it a little bit complicated. And then overall, just communicating clearly and transparently with consumers, how AI is used, if there's human oversight involved, their rights to opt out of things like automated decision-making technology, providing them clear alternatives, letting them know about rights to appeal and how decisions are made, just to make sure that, you're operating with your service providers and then maintaining, I feel like, trust and respect with consumers as well that are being kind of subject to these uses.
Thank you. I think we've come to the end of our session. I'd really like to thank my panelists, Munib and Caitlin, for your interesting thoughts on your areas of practice in your different jurisdictions. Quite insightful. And as we log off and hand over the session back to Alessandro, 2 words that describe your outlook in terms of AI and privacy in the future. Just 2 words. What would you say you're looking forward to seeing in this particular sector and in this particular practice area? 2 adjectives, actually. 2 adjectives.
It's going to be interesting times ahead.
I will say hopeful and excited to learn as we go.
Agree. I think for me, I'm looking at agility and transparency. I want to see how people will be transparent and how people will be able to just switch over. So I'd like to thank you, Munib, Caitlin. I'd like to thank you, the participants who logged in for our session, and I hope you've been able to take away some valid and practical pointers that you can use in your organization. Alessandro, I'll hand over the microphone back to you and your team. Thank you.
Thank you, Janet, for the wonderful moderation, and to Caitlin and Munib for joining us in this insightful and I must also admit fun session. There was a lot of exchange also with our audience and questions, and hope that the closing remarks from Janet and the words you have chosen for this topic in 2026 will remain. It's something that sounds interesting and engaging. We will delve a bit more into the topic, by the way, because the next session remains on AI. We just shift the sector. We've been focusing on it on health and on fintech now in this last session. We are now moving on AI in the recruitment sector, where I believe there might be some similarities but also differences from what we have been witnessing for the session on fintech in particular. Before we close that, and we couldn't mention these at the beginning, but I would really like to mention the presence of Munib as one of our guests, because he's also been writing a book very recently that we are going to link through our event that is titled Data Privacy, a Practical Handbook on Governance and Operations, which made him a perfect presence for this session. So we also wanted to thank him for accepting our invitation in the session. And now I'd like to leave the floor to our next moderator, which I have the pleasure of briefly introducing. Is someone that we already know at the Privacy Rules team. His name is Mike Swift. He is the Chief Global Digital Risk Correspondent at MLEX. Hello, Mike. Now I can also see
Alessandro, good to see you.
It's a pleasure. So I think, we're moving towards another very interesting sector still on AI. We have this time, different countries involved. Differently from the previous session. So I leave the floor to you. I know I'm in good hands for sharing something about the session and then introducing the panelists. So thanks a lot for being with us, to you and the MLEX team today.
Yeah, it's great to be here. My name is Mike Swift. I'm the Chief Global Digital Risk Correspondent at MLEX Market Insight. We're a global news service that focuses on the intersection between technology and the law. Last week, MLEX reported on a lawsuit alleging a cutting-edge Silicon Valley AI startup, employment screening company Eightfold AI, was violating one of the world's oldest digital privacy laws, the United States Fair Credit Reporting Act. Passed in 1970, the same year the Beatles broke up, FCRA classifies companies that collect consumer financial data as consumer reporting agencies and requires CRAs to allow consumers to review and dispute any inaccuracies in data held about them. Eightfold AI, according to the suit, is, and I'm going to quote from the complaint, collecting personal data such as social media profiles, location data, internet and device activity, cookies, and other tracking to create a profile about the candidate's behavior, attitudes, intelligence, aptitudes, and other characteristics that applicants never included in their job application. Because it never got consent from plaintiffs before collecting that data to help decide their suitability to be employment candidates, Eightfold AI is a consumer reporting agency, and it violated FCRA, the plaintiffs allege. Today, we're not going to be focused on the US, but on the EU and Canada. And we have two terrific speakers, one from Europe and one from Canada. That's Andre Verratti and Kristen Pennington, to work through issues around the use of AI in the employment context. Among the topics we're going to discuss are governance and use case authorization, when AI becomes high risk in employment recruitment, data protection aspects, and practical pitfalls and takeaways that legal counsel need to be aware of. But I think it's an interesting takeaway that practitioners in any jurisdiction don't have to just worry about new laws like the EU's AI Act and any legal challenge to new generative AI technology in the employment context. Cases like Eightfold, the Eightfold case, suggest that older laws like FCRA could be significant too. There is also an example of that in Canada, where the Office of the Privacy Commissioner of Canada is investigating whether ex-generative AI chatbot Grok violated the Personal Information Protection and Electronic Documents Act, PIPEDA, which was passed way back in 2000. The Eightfold case also suggests that the courts, as well as industry regulators, at least in some countries such as the US, are going to be key determiners of what AI can and cannot do in the employment context. So let's get into our conversation. I'm going to introduce our two great speakers today. On our left is Kristen Pennington. Kristen maintains a dynamic practice in privacy and data protection law. She's, I should have mentioned, she's a partner at Macmillan in Toronto, I believe. She assists emerging and established companies across a range of industries, providing insights into Canada's distinct laws in these disciplines to support businesses entering or investing in the Canadian market. She also regularly collaborates with international counsel to advise on Canadian privacy law considerations of multi-jurisdictional projects. And she's been a great and authoritative source to me over the years, and I really appreciate that in reporting on Canada. On our right is Andre Verratti. Andre is a partner and leads, he's a partner at VJT Partners, I should say, and he leads VJT and Partners data protection and privacy practice. He has substantial international experience in data protection, digital transformation, and other information technology matters. He's the head of the VJT and Partners award-winning data protection team and the main developer of the legal context of the Adat Solim, I hope I pronounced that properly, GDPR compliant software. That's really very impressive. His experience also includes drafting and negotiating cloud computing deals for both customers and suppliers in a range of industries, including IT and insurance. Thanks both of you for being here. I know we're going to have a great discussion. So I'm going to start off with a question for Andre.
Yes.
Andre, when organizations look at AI in employment recruitment, there's often a temptation to jump straight into the tool or the use case. But from your perspective, where should organizations actually start?
Yeah, that is a great question, and I would definitely pause and step back a bit and not rush with the implementation of the use case, because I think your examples show that if we do not have the right framework for AI compliance and organizations just accelerate with dozens of new use cases and they just move fast and break things, that will have a catastrophic impact. So we have to build an AI governance framework first to prevent this acceleration and give a structure to grow and be safe at the same time. And what this governance means? First of all, it means that we have a system to assess each use case, to identify risks, to analyze risks, and put appropriate controls. This process helps us to recognize, for example, whether social scoring of employees is allowed from this example, or can we use emotion recognition in employment context. So use case authorization process is very important. And beyond use case authorization, it is also very important to build up due diligence of third-party AI providers. Because if you don't understand how the model works, whether the model is explainable, how the model could make a mistake, how it could be misused, if we don't understand these basic things, we will not be able to use AI for HR safely. And of course, governance also means stakeholder mapping, because we need ownership. We have to define who will identify and assess risks, who will authorize new HR use cases, who will monitor deployment and implementation of new use cases. So my brief takeaway that you should start with building up this basic governance framework, because if you don't have a governance and implement HR use cases without a governance framework, that will be like driving a car without a steering wheel. You can drive it, but you will not know where you will head.
Well, staying with your steering wheel metaphor, before even getting into compliance, how should organizations decide whether an AI use case is one they should be driving at all?
That is also a very important question. So first, as I said, we have to build up this basic governance framework, and then we will know how to drive this AI car. But after that, once we have this framework, we always have to go back to the framework and comply with the processes of this framework. And this means that we always have to go back to the same use case authorization process. And this use case authorization process, among other things, practically means that we have a process to identify prohibited and high-risk use cases categories, as well as mapping potential harms to assess and mitigate those harms. And what is very important to say here that this is not just about copy-pasting list of AI categories, prohibited and high-risk categories from the AI Act. It is not as much straightforward as it sounds, because, for example, if we take emotion recognition, we know that it is prohibited in the employment context. But we also have to interpret what emotion recognition in employment context means. Does it means only psychological state, or also physical state? If from physical state we can infer emotions. So building up processes to interpret these categories is very important. And the other thing in a use case authorization process to remember is that it is not just about AI Act labeling, because even if a use case does not fall under the high risk or prohibited category under the AI Act, we could still face risks like hallucination or lack of transparency, and we have to handle those risks. So in any case, regardless how it is labeled in the AI Act, we always have to assess the impact of each new use case. That is why impact assessment is the key part of the use case authorization.
Wow, that's really fascinating, and it gives you a sense as to how complex some of these legal analyses might be. Kristen, let's go over to you, and let's make this even more concrete and move into recruitment from a Canadian perspective. From your view, when does AI-supported recruitment become legally sensitive, and why does that matter?
Thanks, Mike. Happy Data Privacy Day. Glad to join you today. I think that it's always legally sensitive, to be quite honest. So one thing to remember about Canada is that although we don't yet have comprehensive legislation that specifically governs the development or the deployment of AI tools, including during recruitment, we do have a patchwork of existing technology agnostic privacy, human rights, and employment laws. And our regulators have been really clear in Canada that organizations that are using AI for recruitment purposes are subject to these laws, even though they may not specifically reference AI right now. So depending on the nature of an employer's business and how many different provinces they're hiring in Canada, an employer can be subject to various different pieces of legislation across various different disciplines. as well as a bunch of guidance that's been released by regulators in various different provinces. And failing to meet these requirements can lead to a variety of legal consequences. You've referenced, a very significant class action lawsuit in the United States. We have the same concept up here in Canada, but also, of course, there are complaints to regulators, investigations by regulators, and in some cases, potentially significant fines. So I'll give you just a couple of concrete examples of the sort of niche requirements that an employer hiring in Canada might not be aware of, but that can really get you into some hot water if you're not aware that they exist before you implement an AI-enabled tool. So one example is, as of January 1st of this year, provincially regulated employers that are subject to Ontario's Employment Standards Act are generally required to disclose in their publicly advertised job postings that they use AI to screen, assess, or select job applicants. So again, the point here is the requirement doesn't arise from any AI-specific legislation. It was actually passed as part of a much broader amendment to general employment standards legislation in the province of Ontario. I'll give you one other example. So in the province of Quebec, which is quite a large market in Canada, their private sector privacy legislation requires that an employer who uses personal information to make a decision based exclusively on the automated processing of that information, they have to advise the individual that they're doing this no later than the time when the individual is advised of the decision itself. And then the individual has the right to request lots of additional information about the automated decision-making process. And they also have to be given the opportunity to submit observations to a member of the employer's personnel who's in a position to review that decision. So again, no specific mention of AI here in this particular requirement, but you can appreciate how it'll often be triggered if your organization is using an AI-enabled recruitment tool for an automated decision-making purpose. So I think the key takeaway here for Canada, like other jurisdictions that don't yet have comprehensive AI-specific legislation, is it's still really important to understand the local legal nuances and how laws of more general application can actually impose requirements or restrictions that apply to the use of AI in recruitment.
So it sounds like in Canada, similar to the US, it's super important to be cognizant of provincial law and not just federal law, and that there can be a big difference between from one province to another, right? So
yes, absolutely.
Yeah. That's fascinating. Andre, turning back to Europe, under the AI Act, recruitment is treated as a high-risk use case. Could you just give us a primer on what does that mean in practice for HR teams? Does it affect everyone? And where should HR actually focus?
In recruitment in the EU, AI becomes high risk once it goes beyond administrative support and starts meaningfully shaping the recruitment decision itself. So, for example, summarizing CV is just an administrative task. But if we rank candidates, filter candidates out, or score the candidates with the AI, that could meaningfully shape the final recruitment decision. And that could typically bring this recruitment into the high-risk AI Act category. And if this high-risk category applies, then for this use case, HR should follow all the compliance obligations from the AI Act. And without going into too many details and taking a very deep dive of the AI Act, which is very complex, the bottom line is that employers in such a case particularly need to understand the limitations of the tool they use. For example, they need to know when bias could occur, how outputs can drift over time as the applicant data changes, historically or over time. And overall, the employer needs to know what the system can and cannot do. So all these means that under the AI Act, human oversight really becomes crucial, and human review cannot be symbolic. So HR teams must be able to question, challenge, and override outputs in practice. And of course, this goes together with transparency and explainability, because if HR cannot explain why the candidate was ranked lower, then probably something is wrong with the governance.
Great. Yeah. Criticality of human in the loop. Kristen, bringing this back to day-to-day practice, how does data protection come to play in Canada once AI outputs start influencing who is shortlisted or rejected? And does Canada's privacy by design approach, which was originally developed there, help organizations manage this in practice?
Yeah, for sure. So it sounds like we have a lot of overlap with the EU in this respect. So one of the key principles of Canadian privacy legislation and one of the biggest areas of risk that arises when you're using AI-enabled recruitment tools is accuracy. So our privacy regulators have been very clear that the onus is on the organization that uses the AI tool to take reasonable steps to make sure that the outputs from that tool are as accurate as necessary.
I think we might have just. Oh, you're back.
Oh, sorry. Did I drop off there? We're
You did, but
still
you're
having
back.
bad weather here, so I'm
Okay.
back. Okay, so I was saying accuracy. So our regulators really expect that you'll do your due diligence and take reasonable steps to make sure that the output is as accurate as needed for the purpose. And they've emphasized that this is particularly important where you're using the outputs to make or assist in making decisions about individuals. So that directly relates to recruitment. So long before you actually start rolling out the AI enabled recruitment tool, as Andre was saying, it's important to do your due diligence. So, in that respect, we're very big advocates, and our regulators are very big advocates of conducting what we call privacy impact assessments or PIAs, where you're evaluating the entire life cycle of personal information that will be processed using the AI tool. And you're determining, is this actually fit for purpose? Can we legally use this in the jurisdictions in which we want to use this? And if so, what steps do we need to take to make sure that our deployment of this tool is complying with the various laws that may apply, including privacy and other laws, and also to mitigate any risks associated with using that tool? So we've been helping organizations develop template PIA forms, intake sheets to determine when a PIA is legally required or when it might be prudent to conduct a PIA, and also action sheets and how to track to make sure that you're actually actioning any risks that are identified through your PIA. And having these tools, I think, are in place is really important, particularly if your organization is a frequent adopter of AI tools in contexts like recruitment, because it does help you implement that privacy by design methodology that you mentioned. It bakes privacy and data protection considerations right into your organization's vetting and procurement process, instead of treating privacy reactively or as an afterthought once you've already procured and paid for the tool and are now figuring out how to roll it out.
Great. So question for both of you. We've talked about AI risk and data protection separately, but cross-border setups add another layer of complexity. How do organizations actually break down cross-border and organizational silos in practice?
Do you want me to go first, Andre?
Yeah, you can.
Sure. So, in my experience, I'm actually seeing more and more organizations that are leaning into more regional privacy compliance and AI governance programs instead of trying to deploy one global standard that meets all of the requirements in all of the jurisdictions where they're hiring, particularly if there are many jurisdictions that are relevant. And I think that's because more and more organizations are realizing that trying to have, one form of notice to job applicants, one form of due diligence checklist for vendors, one standard disclaimer for your job postings, and so on, can become very impractical because there are a lot of local nuances to take into account, but you still want the things that you're drafting and the tools that you're developing to be practical so that people actually use them, and so that job candidates understand what it is they're agreeing to and what's happening with their personal information. Also, the legal requirements are developing very rapidly in some areas of the world, more so than others. And organizations are also starting to become, I find, reticent about offering a higher standard in one jurisdiction than may be legally necessary. So we are starting to see a more regional approach, I would say, to the rollout and the procurement of AI generally, but particularly in the recruitment scenario.
Andre, do you want to weigh in there?
I absolutely agree with Kristen, and we are aligned. I also think that standardization is very important. So I would just add that we really have to develop a common baseline to speak the same language. So we have to have a shared AI terminology, same AI principles, same risk taxonomy, and also common risk management framework. And the good thing is that for all these, there are international standards like OECD AI principle or ISO or NST AI frameworks. And these are pretty agnostic frameworks which could serve as a good baseline and later tailor-made for the organization. I think these international frameworks could help to bridge the silos in a cross-border context.
Great. I think we have a question from the audience. We're rapidly approaching the end of our time, so let's try and get to these. One question from the audience I see here is, privacy used to be a list of legal checkboxes. Now that AI is high risk and automated, has it officially become a problem that engineers have to solve because lawyers no longer can? There's a good question. Do we need engineers to
I was going to say we may be a bit biased with the panelists that you have today, but listen, I mean, I think like any technology, a lawyer that's practicing in this area has to speak the lingo, has to understand the concepts, and I'll never represent that I'm as technologically sophisticated as an engineer. But I think if you're an effective lawyer and you're trying to develop an effective privacy compliance program for your client, you need to understand a baseline of the lingo, and you need to understand who you need to partner with. So who are the internal stakeholders? And that extends beyond setting up the compliance program. Like we can draft a wonderful policy that we think is great on paper, but if you're not able to deploy within your organization understandable role-specific training for the staff that are actually going to be implementing these policies and procedures and responsible for using these tools properly, then your AI and privacy compliance program are not going to be particularly effective. So at the end of the day, you do have to be able to not dumb down, but to simplify some of these more complex technological engineering, concepts, so that everyday personnel who are just doing their duties and responsibilities are able to understand them and deploy these tools responsibly. So I think there needs to be necessarily a seat for everybody at the table in order for your compliance program to be effective.
Great. Andre, do you want to weigh in on that? Or
I think that question made sense, and it is definitely also about engineering. The privacy by design principle is exactly about implementing privacy controls right to the architecture of the AI system, and lawyers and engineers need to work together. There are many engineering questions like how to build up the training data, how to validate them and test them. This all goes, for example, with goes together with the GDPR principle of accuracy, or how to anonymize and pseudonymize data. So there are really a lot of engineering questions, and it is also a very important part of AI governance. In my responses, I emphasize more the governance controls in AI governance, the organizational part, but I think in this sense, technical controls are also very important, and these technical controls belong also to engineering.
Okay. Maybe we'll just do one more quick audience question. We're getting some really great, very, very thoughtful questions. In a world where we can no longer trust our eyes or ears in a remote meeting, how does a data protection officer or a board verify that the person they're, quote, hiring or authorizing is actually a human and not a synthetic clone? I can attest I'm not a bot, by the way, but how would you guys answer that?
Andre, you want to go first this time?
No, ladies first.
I mean, in-person hiring and in-person interviewing is still a concept. So I think it goes back to Andre's point about use cases. And if you have genuine concerns about the accuracy, about your ability to verify somebody's identity and understand that you're speaking to the person that you think you're speaking to, take a step back about whether we really ought to be using that tool. Is that tool fit for purpose? And I do think sometimes, particularly given the pressure that vendors place on potential customers to use certain tools or to really hail the benefits of those tools, we may actually be overcomplicating things that we know how to do. So I appreciate it's a bit of a cop out, and it is a hybrid and remote world these days with different working arrangements. But Andre's earlier point about going back to basics and considering whether this tool actually is something you need to be using is always a conversation that we have with clients before we get into, technically what are the compliance steps we need to be taking here.
Okay. I know we're really at time here, and we all have other things to do today, but just to close, do either of you have really just one sentence to add about sort of this topic, just to put a cherry on top?
Who should start?
You first this time, Andre.
Okay. Well, my short takeaway is that many times AI in recruitment doesn't fall because of bad technology, but falls because poor organization and governance, because employers do not have governance and do not understand the tool. And if we just follow some very basic rules like understanding the tool, reading the technical documentation of the service provider to understand the limitation, and the HR will be capable to explain, challenge, and control AI outputs, then most of the legal and ethical risks could become manageable in HR context.
And mine is something we didn't have time to really get to, but just be wary of vendors placing pressure on you to accept standard form agreements, which we're seeing a lot of problematic clauses buried in terms of use or standard form agreements, allowing vendors to use your organization's data, including job applicants' data, for their own purposes, including training and improving their AI solutions. So make sure that you're entering into appropriate privacy and data protection terms with your vendors who are providing these tools, and in particular, be alert to any quote unquote standard form agreements or terms of use or click-through agreements, because there can be lots of contractual landmines in there that we want to avoid.
Fantastic. I'd like to thank our two great speakers today, Kristen Pennington of Macmillan and Andre Veradi of VJT Partners. It's been a great discussion, super questions from the audience. I'm sorry we couldn't get to all of them, but this has been a terrific session. Thank you both very much.
And thank you, Mike, from our side for your wonderful moderation of the session. We were aware of that, given your role at MLEX and your natural and daily profession. But thanks a lot also to you for joining us. I think it's a bittersweet part of the day, meaning that we are closing after a day of several sessions on very interesting topics. So I will leave now our speakers. Thank you all for being in the session. I'd like also to thank all our panelists and our guests of today for joining us. I thank also our audience for staying for such a very long day. I think it was a good way for you all to enjoy a happy data protection day. And I also hope that this was useful and that you got through those sessions practical guidance to strengthen your governance and compliance framework. Of course, whenever you need any type of support on data protection, cybersecurity, any other privacy-related matters, since this is the topic of the day, feel free to contact me, Privacy Rules, or anyone that was in the session of today. Thank you all for being part of this journey. We really wish you all a great and data protected 2026. Bye, everyone, and till the next event.